What if your green card journey becomes harder, even before you file the application? And what if the biggest challenge is no longer your qualification, but your employer? A major proposal from the US Department of Labor could now reshape how the employment based green cards are approved. And for thousands of Indian professionals waiting in the long immigration line, this would be the development worth watching. Hi, this is Navyaval, and you're watching TimesXP Immigration Desk. The focus is on PERM process. The most employment-based green cards begin with a PERM, a labor certification that employers must obtain even before sponsoring for a long worker or permanent residency. But the US government believes that the system lasted in 2004 no longer reflects today's labor market. Officials say that the technology has changed, hiring practices evolved, and rules now need a major overhaul. However, the proposal is much more about modernization. It's more than that. According to the Department of Labor's regulatory agenda, the new framework is expected to place employers under the greater scrutiny. The goal is to ensure the qualified American workers receive priority before the permanent jobs are offered to just the foreign nationals. Although the full proposal has not been released yet, officials are expected to revisit the labor market testing process that sits at the heart of the PERM. Now, that could mean the stricter documentation, more recruitment requirements, stronger proof that employers generally search for the qualified US workers and then were unable to find them, and closer examination of hiring decisions. The proposal is also part of a broader tightening of the employment-based immigration. In the recent months, the administration has already introduced changes to the H-1B visa lottery system and proposed the higher wages requirement for H-1B visa positions. The PERM actually proposes to be appear of the extent of the approach of the green card sponsorship. Under the current system, employers must advertise the position, obtain a prevailing wage determination, and then post internal job notices, list the vacancies to the state workforce agencies, document why American applicants were not selected. It's a long process. But if the new proposal becomes a law, that process could now become even more demanding. For employers, it may mean more paperwork, longer timelines, and greater compliance responsibilities. For foreign professionals, especially thousands of Indian workers waiting for permanent residency, it could mean additional uncertainty in an already lengthy green card process. And at this stage, it is important to remember that these are proposed changes, not the final issues. Well, the administration has not yet released the complete regulatory text, and the proposal is expected to go through the rule-making process before the changes take place. But one thing is becoming certain. Well, the United States is not just changing who qualifies for the employment-based immigration. It is also changing how companies prove that hiring foreign talent is truly necessary for them, and that is the shift every green card applicant should keep an eye on.